Good morning to those of you on the West Coast. Good afternoon to everybody else. My name is Dominic DeMattis. I'm a partner in Thompson Hine's Employee Benefit and Executive Compensation Practice Group. Joining me today is David Whaley, also a partner in our Employee Benefits and Executive Compensation Group. We would like to welcome you to today's webinar. This is the 11th in a series of webinars examining what the shift in presidential power could mean for the country. Today, we will examine what the evolving landscape of employee benefits, the impact of executive orders, and some relevant legislative developments mean for our area. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to you within the next few days that includes the recording. This presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of David and I, and do not necessarily reflect the opinions of any of our clients, any employers, affiliates, or Thompson Hine itself. The content should not be taken as legal advice. The views expressed here are for informational purposes only. If you have questions during the webinar, please feel free to use the question box located in the control panel on the right side of your screen. We will answer as many questions as we can, either during the webinar or at the end. CLE credit for today's webinar is pending. Please be sure to complete the verification of attendance survey. The link to the survey is posted in the chat. We will also paste the link in the chat at the end of the program. I will announce the attendance tracking code at the end of the program. In the handout panel, you can also download a copy of the PowerPoint slides and bios for David and I. Again, thank you for your interest and for joining us. And if you have questions as we go along, please use the question box. So what are we going to talk about today? Well, I mean, at a basic level, it's very hard to kind of understand what we're likely to see from this next Trump administration without at least a decent understanding of some of the executive actions that have been taken. They're defining the playing field for us, and they're also limiting the players. And we'll get into that in a little bit more detail. We'll spend a little bit of time giving some insights into the nominees in our area. We'll take out our crystal ball and talk about maybe some healthcare items that could be coming. And I guess tipping our hand a little bit, some retirement, not looking forward to much policy, but probably some revenue raisers if there is anything in that area. And then, as I mentioned before, we will take questions, and if they come up throughout, we will address them. And if not, we'll handle them at the end.
Yeah, and let's say, Dominic, with respect to the crystal ball, it's probably pretty cloudy, so you can take it with a grain of salt based upon today, April 22nd, 2025, the afternoon of what we're seeing. It'll probably change by tomorrow.
Yeah, that goes back to the earlier comment about this is like our personal opinions, and I guess the part that I forgot to add to that script was that our opinions might change tomorrow, and that's actually been true, David, as we've gone along the last couple of months. So starting off, we'll kick off with executive orders. And I guess I should have mentioned through the agenda that this is probably going to be a bit of a free-for-all between David and I. As you just noticed, he'll pipe in, I'll pipe in. We'll both do this kind of together. So hopefully chaos is okay with everybody. But, I love this quote. I've got a pen and I've got a phone. This is actually a quote from a former president, President Obama, and it is his reaction, if I recall it correctly, to a situation where he could not get anything through a Republican Congress. Some of the stuff we face today is obviously not new. It may go to different lengths or have different extremes, but this quote, I've got a pen, that meant he could sign executive orders, and I've got a phone, that meant he could go out and rally support for his agenda. And I think we've seen presidents follow that kind of pattern, and with each successive president, and it didn't start with Obama, so I'm not picking on or identifying one particular president, but it's just the way it has gone, and in fact, it's become more exaggerated over the years resulting in what we see now with the an extensive number of executive orders.
Well, and
So
Dominic, and some of that, I think
yep.
as you talk about that, I think it's important because it does, to me, shape what we've seen and how we've seen it so early. The conversation from President Obama was such that in the inability to get something through a Republican Congress, now we're seeing this extension to not only an inability to get something through a Republican Congress, but actually just a desire to not even have the need or conversation around a legislative solution. And part of that seems to be because of the knowledge that was gained by many of the individuals that are in this administration from Trump 1.0, and also some acknowledgement that there is a short timeline before the honeymoon of a new presidency wears away, regardless of party. And so as opposed to having conversations around that which could otherwise get through Congress, and I mean, I think if you look at the Affordable Care Act, it was an 18 to 24 month conversation at the beginning of the Obama administration, instead trying to say, how quickly can we change anything? And the easiest place and quickest way to change that is the pen, is the phone, is the and honestly, the phone differently from President Obama picking up the phone and calling. Here, the phone is picking up the phone and tweeting or sending out a message on True Social to try to change the conversation and the narrative. And so you're seeing it used a different way. And I think that these executive orders we talk through and the way in which they will apply have to be seen as that it being used a different way, not good or bad, just a reality of the way in which you read them.
These are excellent points. And in fact, as you said that, it kind of hits me, and, I've thought about this a little before. We're all familiar with, the first 100 days. Presidents would run for office and they'd say, on day one, I'm going to do this. And within my first 100 days, I'm going to do that, right? Or this series of that. Well, with this, we've now seen that evolve to what I'm going to do in the first 5 minutes and what I'm going to do in the first 100 hours. And that is exactly the point, David, that you're making regarding the flurry of executive action. It's not necessarily good or bad. It's just the reality of what we face. The other thing that comes to mind, if I remember my history correctly, is that when Obama when that quote was attributed to him, or the time period in which he was making that quote, actually wasn't in the beginning of his term. He had a Democrat Senate and House, and it wasn't until Senator Kennedy passed away that they even lost. They had 60 votes in the Senate before that. So he had a pretty strong congressional contingent, to your point, to work through ACA and other rules. But then later, and it might have even been in his second term, when he had the Republican Congress, that's when that quote actually came out. So it's a very fair point that the context of his comment is very different than the context we're living in right now. So starting to walk through some of these executive actions, if you will, it's nice to start with one that's very common. This regulatory freeze executive order is pretty much a copy and paste from what we see with every administration. And all it really does is it just says, hey, stop the presses. If there's something that was on its way to that made it to the Federal Register but didn't get published, stop, don't do it, and withdraw it, which affected one of our regulations that David will talk about in a second. It also says, hey, look, if there have been any recently published guidance, consider delaying the effective date for 60 days so that agency heads who have been appointed by the president, and that includes an acting, after January 20th of 2025, can take a look at the rule. So David, you want to talk a little bit about this adequate consideration regulation that is very elusive and hard to get?
Yeah, so in Secure 2.0, there was a mandate from Congress to the Department of Labor, specifically the Employee Benefit Security Administration, to issue a regulation for the definition of adequate consideration within ERISA. So it's a different space than when we talk about with respect to the repeal of the Chevron standard and some of the other factors. It actually is a mandate from Congress to issue this regulation. As you might imagine, it's not a terribly newsworthy moment, we'll say, compared to some of the other matters that EBSA and the Department of Labor were working on, but it was being worked on and consistently on the guidance plan and getting through the processes. In October of last year, of 2024, a draft regulation was submitted by EBSA to OMB for its review and its blessing to be able to go to the Federal Register. Things I have learned about the regulatory process, largely thanks to my partner, Mr. DeMattis, about this, is that whenever a regulation goes to be reviewed by the White House, it actually gets submitted back to the agency before it goes to the Federal Register. And so sometime within a week or so prior to the change in administration, the regulation was moved back from the White House to the Department of Labor, and then from the Department of Labor sent to the Federal Register for publishing. But its publication date was 2 days after the inauguration. And so we ended up having a view of a regulation and then actually a safe harbor prohibited transaction exemption accompanying that regulation that went to the Federal Register. It was released pursuant to FOIAs to the multiple of journalists inside of the world that have standing FOIA, and then showed up as withdrawn inside of the Federal Register, literally having blank pages with the words withdrawn shown up in that space in the Federal Register. So it's really a non-proposed adequate consideration reg. Really sort of having and begging this question of what happens to a regulation that not only was proposed and withdrawn, but a regulation that was out there and actually never proposed. Does it actually have some precedential value even in conversation? Is it actually an indication that it is not what is desired or designed to be the regulation, because it was in fact withdrawn pursuant to a modification of administrations that came along? And so it really sort of left a lot of people inside of the industry trying to figure out what the adequate consideration reg is, what the definition is, and how to deal with the fact that there was this unwritten regulation or unpublished regulation that was actually sitting inside of EBSA, inside of the Department of Labor, that really sort of indicates the decision points with respect to that existing Department of Labor, EBSA, pertaining to this issue. I don't think there are a lot of answers with respect to that, other than indicating that it was what the position of the Biden administration and the Biden administration's political appointees and some career officials of what a definition of adequate consideration is for the purposes of ERISA. The interesting factor that really ends up coming to play with respect to this, though, is, and we'll talk about this some a bit later, what does that mean, if anything, with respect to a crowd of individuals that represented either a prior administration or actually represented career individuals who may very well be downsized or modified as a part of a different view of the way in which the federal government should be run, and is apparently running from this point for at least this administration.
Thank you. Yeah, and we will get into some of that pretty quickly here. One unrelated thing before we flip from this slide, I know I mentioned earlier that this was, and I guess, boy, it says standard operating procedure right on top. And I kind of mentioned that, hey, this was standard operating procedure. Actually, maybe not so much, at least with respect to how regulations were defined. Again, personal opinion, I think what may have happened actually to those, some folks may have noticed that some guidance on an annual funding notice came out that was pretty routine, and it certainly wasn't in the form of regulation, yet it didn't come out until sometime maybe a couple weeks ago, very untimely, something that should have been out a long time ago. And my best guess is that actually got caught up in this delay as well, the 60-day delay, which I don't recall being typical in other administrations, that the delay would go down to what I consider to be pretty mundane, routine guidance. All right, so moving along, talking a little bit about the points that David started to raise related to who's left. Well, on February 11th, the president published, or it was published on the website, a presidential, I think it's called an action memo, although I really think it's kind of an executive order, I'm not sure. But it's titled Implementing the President's Department of Government Efficiency Workforce Optimization Initiative. And there was a hiring freeze on January 20th. There was an executive order published on January 20th that had a typical well, not typical, but it's what's become typical for, I guess, the two Trump administration's hiring freeze. But then it was followed up by this one on February 9th or 11th, which was different. And specifically, it said, hey, agencies, can't hire more than one for every 4 who depart. Well, that kind of is on agency wide. And as David kind of alluded to earlier, our space in the world is a subset of all these agencies. I mean, we have a small group of folks at the Department of the Treasury, at Main Treasury, as some of us call it, where that focus on employee benefits and fringe benefits and employment tax issues. But that's not agency-wide. We have folks in the Office of Chief Counsel at IRS that focus on it, but of course, there's lots of other folks in IRS Chief Counsel who don't. And then, of course, the IRS has, 100 or 60,000 employees, depending upon where we land. But so this idea of one depart, you have to have 4 departing before you could get 1 hired, can raise some really serious issues for our place in the world. If you have a small group of 5 people, one of whom leaves, and you're required, you need to have people leaving across the agency to somehow be counted up to replace that person, you can see that it could be pretty hard to rehire or to fill spots for people who leave. And in addition to that, at the same time, the agencies are all initiating these large-scale reductions in force. These reductions in force, I think we're starting to see them play out now. When this was originally published, it wasn't quite clear exactly what they were going to entail. But essentially, each agency was charged with sending to OMB a plan, if you will. I think they even defined it as the word plan. And it was to be prioritized on doing things like eliminating offices that perform functions that are not mandated by statute or other law. Of course, it attacked DEI, and we've heard about the impacts of that and those employees who had worked on and focused on DEI initiatives. But it also focused on employees who were not deemed essential during a lapse in appropriations. Well, many of the people who work on employee benefits, fringe benefits, employment tax matters are not deemed essential during a lapse of appropriations. I can attest to that. In November, October of 2012, during the government shutdown, when I was at Main Treasury, I was sent home and not permitted to work. And so, it's arguably none of the folks in our area are essential, at least by this definition, which is a pretty harsh thing to say. But, that's the reality that we're faced with. The agency heads were also supposed to send to OMB a report saying which parts of their agency, could be eliminated, could be consolidated. And that, gave rise to some concern about, maybe some parts or some functions related to employee benefits generally being eliminated. We don't know. We don't have anything on that. And I'm not even I don't want to guess. I don't think, David, I don't think you want to guess about that kind of stuff, because that gets, pretty dicey to do. I've heard speculation. And I guess what I would say about that is I would ignore the speculation here. Let's just see how this plays out over the next couple of months. One thing that we have seen is that there was a second, originally at the same time this was happening, the OMB actually sent that fork in the road email that I think is famous, folks have heard about, that had, I think some feds questioned whether or not OMB actually had authority to do that. My understanding is that there's been a second level of, I'll call them buyouts, if you will, that have been initiated through agency HR or through vehicles that are more reliable. It essentially would provide for somebody to leave starting, April 25th, 28th, I've heard different dates, but be paid through September 30th. And apparently during that second sweep, if you will, 20,000 IRS employees said yes, they put their hands up and wanted to take it. And as many as 10% of them were actually denied because it was just too many. The other issue that comes up with this, it's kind of related, is that just in the OMB process, as David alluded to, with respect to the adequate consideration reg, all guidance is reviewed through OMB, but there had been a reprieve. Before Trump won, there had been I'll call it a lightened process for the Department of the Treasury and IRS regulations, and also the what are often referred to as the independent agencies like SEC. They didn't go through that process, but they now do, and Treasury is now put through the full gamut.
Yeah, and so it's interesting because I think that we get to sort of this thought and the question pertaining to what's up on the slide, deregulation. It's kind of a space in which we're living, and what I'm referring to as in a post-regulatory world, at least right now. And I think that kind of takes two spots and two questions. So post-regulatory meaning sort of, if you think about it, the investigation or the means in which the government interacts inside of the operations of our companies, and post-regulatory in the space in which there's just less regulation written. And I think we have to think about those separately. If we look at or think about the less individuals inside of the government, and we think about our practice areas with less individuals inside of our government, it really kind of gets us to a spot that the individuals that are charged with doing a task with less people have one of two solutions. Let's take the termination letter programming or VCP applications and retirement plans. If there's still the same number coming in, and there's zero reason to believe that the number of applications in either of those would go up or go down as a result of a change in administration, if there's still the same number of applications coming in and there are less people to work on those, now we don't know whether or not that the 1 for 4 scenarios are going to impact the areas that we exactly practice in, but you have to assume that there's going to be some lesser headcount inside of those worlds than what has otherwise been historically there. If there are less people to work those files that we submit, there's only one of two things that can happen. One thing, the response time gets slower, and slower to a point that it actually is not beneficial potentially to an employer with respect to a VCP or a favorable determination letter application. That's one potential. Or two, it gets such that their responses are faster because the review is not as verbose or strong as what it had been historically in our practice. Now, I'm not saying that either of those are necessarily going to happen, but I think that one of those two paths is probably a logical conclusion of what a reduction of headcount would be inside of those groups. But secondarily, it means that the way we advise our clients, the way we think about these things, I think has to be modified. If our goal is to actually talk through a VCP application with a client, but it's going to take 2.5 to 3 years to get a response because of the lower number of individuals that are working inside of that space, maybe it's not as beneficial to our client to actually seek that solution. If instead the opposite of that is that any favorable determination letter that gets submitted is going to be blessed as being a qualified plan, we have to understand that maybe the protection that we believe we received from a favorable determination letter is not as strong as what it had historically been with respect to a plan. So I think that what we have to do is we all have to begin to think about what does it mean to work inside of a post-regulatory, at least during this period, time frame with respect to those interactions with government agencies and officials in ways that differ from what we have historically. I don't have an answer for that for my clients yet. I've talked through some of this with some of my clients, but I think that it's a necessary element to think through that some of the staffing with respect to a post-regulatory world being lower, what does that mean with respect to our jobs, our advice, our abilities to communicate to our clients? It invariably means that our clients probably end up with more risk and not really a good assessment of what that risk could otherwise look like. But I think that that's something we have to talk about, think about, understand.
I agree. And, another potential, effect of this is that it puts a lot more pressure on us, on advisors. It's not as if I had heard suggestions at one point back when the IRS was making changes to the determination letter program back in the 2010s. I'd heard suggestions that some may have believed that maybe, maybe ERISA counsel, the tax counsel was relying on the IRS to bless plans without necessarily putting in as much work as should be put in to make sure that the plan terms are drafted in a compliant way to begin with. That's certainly not something I ever experienced in private practice. Anybody I ever worked with, including myself, I mean, we worked as hard as we could, obviously, to put in place a legally compliant plan with the realization that the IRS, with its then many checklists, may not necessarily agree with the way something had been worded. and we go about our business to change it. Well, now, you know, if the outcome is that we get to a place where there's not much substantive review, and that letter, sure, it still should be a shield, I would expect, against sanctions from the IRS on an exam, but it may not have quite the power that it once had in terms of being reliable as to the actual terms being compliant. Well, that puts a lot more pressure on legal advice to ensure that it's effectively, and you know, you kind of give it an opinion, right? You draft a plan provision, and your clients expect that language that you're giving them complies with the law, and there isn't necessarily the backstop of, say, an IRS process that can save you from, say, an honest mistake or, you know, a wording that's slightly different than the IRS might have wanted to see based on a checklist. All right, so moving on to, well, and then the other thing, actually, before we move on, and we're going to hit this a bit, and I think it's the next slide, but very soon, the headcount item issue that David, that you and I both have talked about, but you just hit on again with your last point, you know, there's really a double whammy there. Not only do we have the reduction in headcount, but as we're going to talk about in, I think it'll start in the next slide in particular, is the fewer people who are remaining are being told what to do. Their time is being eaten up by all these executive orders or these executive actions, which is one of the reasons why it's so important to spend the time we're spending on the executive actions, because that really is going to inform what those fewer people are doing. And there's not one executive action so far that's focused on a determination letter program or EPCRS or any of those other types of things that we've come to rely on as a regulated community. There are things that in our area that will affect us, that will affect, you know, all of you in the audience, that, you know, the people who otherwise might be working on those types of initiatives instead will be working on these other items that we'll talk about. But first, setting the table just with the general deregulation guidance, the first piece of our executive order that came out just said to agencies, hey, if you need to eliminate 10 pieces of guidance for every regulation that you issue. This is in contrast to Trump 1, when the regulatory reduction goal was 2 for 1, and when the definition of regulation was actually quite different than it is now. We'll talk about that in a second. There's also a cap on the total cost with respect to 2025 fiscal year. The incremental cost of any new regulations, including repeals, shall be significantly less than zero. I don't know what that means, but I know it means negative. So that's that. And then really importantly, I think the term regulation, and this is what I kind of was alluding to before with even that first day pause, this White House views regulation very broadly. Any agency statement of general particular applicability and future effect. So this includes, you know, like FABs, it includes, you know, any type of FAQs, anything at all is considered a regulation under these rules.
No, and honestly, Dominic, one of the things, I mean, we had some pausing of this, but if you think back to sort of the question and answer response from the JCEB inside of our community, I think that even something of that nature would have probably been potentially swept up in what their definition of regulation was. The bigger challenge that I have with respect to this in the 1 for 10, there are some things that are absolutely required. A modification to the Form 5500. Is that a regulation that then has to have 10 offsetting regulations? And particularly going back to the adequate consideration regulation that was never published, I would personally love to see that published. There's a statutory requirement to publish that. I would love to see some of those statutory things, the adequate consideration reg forms, be offset from the 10 for 1 requirement.
I agree. I think it's very unclear exactly how those types of questions are going to be settled. I mean, my recollection from Trump 1 is that at least there seemed to be, as an outsider, I wasn't in the government, there seemed to be a lot of exceptions to the 2 for 1 rule. And eventually, it at least seemed to me as an outsider that nobody was really paying much attention to the 2 for 1 rule. That in fact, we were getting guidance, you know, at some point, you know, not much differently. it reflected obviously the policy priorities of the administration, but in terms of cadence, it really turned out to not be that much different than the presidents before or after. This time, I think, I don't think there's an analog, and I don't think we can look to Trump 1 as an analog for what's going to occur here. So in implementing this deregulation, executive order, there were additional memos, actions, executive orders that, came out that went further than, to the point of there being no analog. Well, these types of things were not published during Trump 1. And so really we have no way to know how all of this will fly out. But essentially the first step was that agency heads were directed to identify classes of regulations, within 60 days of the publishing. This was published back in later February. Just to identify classes of regulations that in the view of the agency heads, but the agency heads obviously are, the Secretary of the Treasury, the Secretary of Labor. They're not sitting down and reviewing regulations. Okay, this is going downstream to those fewer employees who are left. So to the extent that there's stuff, you may say, well, how much stuff of this is in our area? I'm not sure that matters, because they're all getting the directive to spend their time focused on looking at for these types of things, on unconstitutional regulations or regulations that raise serious constitutional difficulties, that exceed the scope of power vested in the federal government by the Constitution, or unlawful delegations of legislative power. I mean, that's huge. And what does that even mean? Well, clearly there's not a legal standard. What is it? I mean, we all have our opinions as to what might be an unconstitutional regulation, but that's, this executive order is not saying, hey, tell me the things that have objectively been determined to be unconstitutional. It's saying you go back with your teams, and in each of your individual micro areas of expertise, you come up with a list of things that you think might be unconstitutional, and we'll put them in the basket. Regulations that are based on anything other than a best reading of the underlying statutory authority or prohibition. I mean, that seems to imply that there are regulations out there that aren't based on a best reading of the statute. And where are they? We have to go find them. Well, who's going to find them? It's the employees who are left. They're not going to be working on the other stuff. They have been finding these or looking for these. And you can read the others here. I mean, but the big picture point is that, well, what have folks been doing in the agencies? The ones that are left, the ones that have jobs, well, they're starting to do this. Then there was subsequent memo that said, hey, now that you've identified those regulations, and this one I think was from April 9th, now that you've identified those regulations, or you're in the process of identifying the regulations, you need to take steps to repeal the identified regulations that clearly exceed the agency's statutory authority. And that review was directed to be focused on a number of Supreme Court cases, with the first one being Loper-Bright. So, Loper-Bright was essentially the case that kind of undid the Chevron deference to agency rulemaking. And, we could spend an hour talking about Loper-Bright, so I'm not going to do that. But I guess I would just underscore the reality that, it's really, I guess if you read Loper-Bright, it's kind of up to a court to decide whether or not the regulation, exceeds the statutory authority. That's the message that Loper-Bright says. But by putting this in an executive order, essentially, agencies are being told, you figure out for yourselves which of your own regulations you think violate that Loper-Bright standard, that are not kind of a best reading of the statute, which is one way to phrase that case. And that's a very difficult thing to do in an objective way.
Well, and the biggest challenge that with is the second bullet, right? I mean, that's all fine. That is what our system of government was built on, so long as you follow the notice and comment. If these regulations are, quote, repealed by a singular action of a secretary or the president without following the Administrative Procedures Act, are they in fact repealed? And that's a really hard spot to put an employer in.
That's exactly right. And where it's likely to lead, I mean, and we're going to play through what they've done so far, which hints, and it's benign, but, you know, the expectation is that there are going to be decisions made under this standard that are quite edgy, and there will likely be things that are repealed. Maybe they're going to be repealed without notice and comment, to David's point. And what do you know? There might be someone who doesn't disagree. Well, what happens when people don't agree with administrative action? They head straight to court. And so now we've got a potential situation. In addition to, I mean, one of the nice things, in my mind anyway, about Loper Bright, I mean, I think there was a lot of, I mean, some people thought the sky was falling and everything is going to get challenged. I mean, my thinking was kind of like, well, look, Chevron had died a long time ago. And the fact is that a lot of the controversial regulations already are challenged. So, you know what, like, maybe we'll just go through a painful period and get over it. But at least that would be focused on what we may call the controversial regulations, or the regulations that flip-flop between presidents of different parties. But here, we've now introduced the possibility of a whole new class of regulations being challenged. That is the repeal of a regulation that someone may argue, you know, wasn't consistent, couldn't be repealed consistent with the good cause exception, which, by the way, the good cause exception essentially allows an agency to not use notice and comment rulemaking when it would be impractical, unnecessary, or contrary to the public interest. And what the White House says in this particular memo is, and I'm quoting, retaining and enforcing facially unlawful regulations is clearly contrary to the public interest. Furthermore, notice and comment proceedings are unnecessary where repeal is required as a matter of law to ensure consistency with the ruling of the United States Supreme Court. Agencies thus have ample cause and legal authority to immediately repeal unlawful regulations. So, you know, that there's likely to be a class of regulations now that are going to be repealed without notice and comment, and there will be groups of folks who completely disagree with that, and we will see, I would expect, significant legal challenges. The other part of this particular memo was, and this is a little bit of a, I mean, this is just my reading of it, it's a little bit of a shot across the bow to the agency staff, to the agencies. It's like, you know, first we told you back in February, hey, go through your process and identify some regulations that are ripe for us to get rid of. And then, hey, now you've done that, go ahead and repeal the ones, and please do it without notice and comment if you can do it that way through this good cause exception and what might be a very broad reading of good cause exception. We'll see. But then, oh, for those that you decided you weren't going to repeal, we want you to send us a one-pager giving us the reasons why you thought that regulation should not be repealed. In other words, you identified, the agency staff, because of course, like I said, the secretaries, and we all know, aren't doing this stuff. Agency staff, you identify those things. Now that you've identified it, you're stuck. You either have to take action to repeal it, or you have to explain to OMB why you're not.
So I desperately want to see the one pager on why 409 Cap A's regs stay.
Well, you'll be happy to know that in IRS Notice 2025-22, which is the initial response, one of the 9 pieces of guidance that was revoked was a 409 Cap A regulation, but it actually had to do with TARP. That when Treasury, back when Treasury acquired interest in financial institutions, some of those interests involved acquiring equity during the financial crisis. And there was an open question at the time as to whether that might constitute a 409 Cap A change of control. And of course, that can't be the answer because that's not what the answer the government wanted. So IRS notice was published in 2009 that said, no, that's not a 409 Cap A change of control. Well, that's one of them that's been revoked. Do I think anybody's going to challenge that? No, like, you know, that's what I mean. I mean, we're starting out with stuff here that's pretty benign. And so that was part of the initial response, that IRS Notice 2025-22. That dealt with IRS guidance. And it says in the notice itself that they anticipate revoking or obsoleting hundreds of similar guidance documents in the near future. So that's the real question, is what's in those hundreds? And then there was also a direct final rule from the departmental officers at Maine Treasury, and that dealt with, it basically it repealed some TARP and other financial crisis era rules, nothing that affects our area, but, and also some banking rules, if I remember correctly. But in that case, a direct final rule is kind of like, actually, it's kind of like, it's similar to this idea of not having notice and comment, because under a direct final rule, and if you go back and read it, so you'll get a little flavor if you're interested in, by just taking a look at how they handle that particular regulation. It just says, hey, this is what we're doing. We're repealing these rules. And by the way, if you disagree, send us comments. And if at the end of the comment period, you know, they don't see a reason to change course, then the final rule becomes effective. And if at the end of the comment period, comments raise, you know, issues that the agency feels like it needs to address, then they would go back and actually propose the repeal of these regulations and go through a notice and comment process. We'll see if that's what they mean by other types of repeals, or if they're going to use a different process. So David, what do you think about other candidates here? ESG, fiduciary rule, crypto?
I mean, all of the things that you would see that had been otherwise mentioned in other spaces of guidance from this administration, and that also touch our area, right? Those are the type. So you're seeing a goal of increasing crypto, and honestly, at some level, they're talking about the means or desire to have a crypto reserve on the Fed balance sheet, right? So some of that's going to end up touching our world. Those are going to be the hot buttons. There'll be things we don't see though, that will come out of left field to us. That's what's super interesting about sort of the flooding the zone nature of what's happened with respect to this administration. Not only I think that sometimes nobody in the administration could see that they touched some of these spots, but also sometimes we don't know that people inside of the administration are intending to touch some spots. And so I think there'll be surprises as we go through this process.
Yeah, I agree completely. I mean, in particular with these first couple, I guess I'll stick my neck out. It wouldn't surprise me at all if the ESG rule remains unchanged. And that's not necessarily because it, you know, made it through a recent district court decision, you know, in the Fifth Circuit. But it's also based a little bit on how, you know, the fact that the truth is that I think we all know the truth is that notwithstanding the food fight that's occurred between administrations for as long as we all can remember, there's really not much difference as a legal matter between the standards that have been applied under a Democrat administration or Republican administration. At the end of the day, I mean, it really does come down to risk and return. So we'll see. We'll see.
Yeah.
The next one was a little bit of a sleeper. There was this executive order about the America First investment policy. All I really want to say about this is that it does the types of things you would expect it to do, promoting certain investments in the United States, discouraging or restricting others, including restricting investments involving foreign adversaries, which are named in the second bullet. But then it does this, has this little paragraph where it directs the Secretary of the Labor to publish updated fiduciary standards for investments in public market securities of foreign adversary companies. And my view is that what appears to be intended here is that DOL is being told, you go adopt a fiduciary rule that prevents investment in foreign adversary companies. We'll have to see how that comes out. But that again goes back to the earlier point. Fewer people being told what to work on.
You know, so yeah, it's okay. So now we kind of get to the health-related executive orders in this conversation towards health and welfare. You know, the executive orders inside of health and welfare really take us into three spots. And I think that it's necessary as you begin to think about these three spots that are the way in which this administration is likely to attack or otherwise really sort of go at modifying the health plan delivery system inside of our country. The first really pertains to and is built around sort of carrying forward the continued mission of the administration on getting rid of DEI, or what they refer to as woke ideas. So you're seeing a prohibition on gender affirming care, and you see these conversations around trying to move towards a quote healthy America that seems to be a little bit of a rosy picture of what 1975 was, right? So you sort of have this thought of, okay, so let's deal with that first, right? So you sort of deal with the DEI initiatives first, and then the second two, if you move forward, the second two spaces in which they are otherwise really looking at or trying to figure out how to modify the employer-provided health system is first transparency and pricing, right? And we saw this actually some in Trump 1, that there's the idea that if we have transparency in pricing with respect to our health plans, our choices in healthcare, that we will actually lower the cost of healthcare. So it's always this sandwich boarding of what healthcare will otherwise cost, not employees, individuals, citizens inside of the marketplace, which honestly, that you can see that has the potential to really, if done, drive down healthcare. I always come back, though, to the challenge that ended up, there was a PhD student at the St. Louis University that pretended that she had a 64-year-old grandmother that was getting her hip replaced. And the 64-year-old's important because she was 1 year before Medicare. And so she called 100 hospitals, 80 random hospitals. Only about 40 to 50 of those hospitals could actually tell her how much the hip replacement was going to cost without insurance. The others really couldn't agglomerate what was going to happen because there are just too many different providers. And then the 20 that she called were the 20 centers of excellence, and the 20 centers of excellence had about the same ability to be able to provide a true estimate of what cost would be. It is unbelievably challenging to make clear the opaque nature and cost of what is healthcare inside of this country. It's a laudable task, but you're seeing that that's one of the things that the administration will aim at. And then the second, if we move forward, is a conversation pertaining to prescription drugs. And not only with respect to one of the questions pertaining to, hey, how do we actually get an effective prescription drug negotiation, handling some of the questions pertaining to the Inflation Reduction Act's requirement that Medicare have group negotiations, but then also some questions pertaining to which we try to influence or modify pharmacy benefit managers being able to price and purchase the drugs that are utilized through plans. And so you're seeing that those are probably the very two likely spots that the administration will dig into inside of its executive orders. But this gets down to a really interesting question. What ability, and something we've talked about a bit, what ability does an executive order have to modify the prescriptions of the law that are encompassed inside of the Affordable Care Act? That's going to be a challenge or a question that actually runs forth. So we get to these thoughts of maybe we'll end up with some movement, but honestly, how much movement can you legally get? And even beyond that, the bigger challenge happens is that if it's a spot that is not able to easily be moved because it's really statutory, if it's a directive to a group of people that's fewer people than what it was, and they have a lot of directives before, we kind of get back to the same spot of the adequate consideration reg. Maybe some of this movement ends up happening about year 3.5 or year 4 of the Trump 2 administration. And so it's the concepts of an idea that don't actually get implemented.
Yep, no, that's all very helpful. I mean, at the end of the day, I think just to sum up all these kind of executive presidential action things, what we have is the net result, or the strategy appears to be fewer people working on prescribed tasks. In other words, to do things that are deregulatory in nature, or to do things that are specific, as you pointed out here and discussed with respect to healthcare, with the ongoing related questions, including how much of this can you actually do by regulation, assuming that there would be a regulation that would do this stuff, and lower funding. So fewer people, a lot for those fewer people to do that's prescribed, and not much money to do it with. That's really, I think, the three-part summary of the presidential action. All right, so we'll take just quickly talking about some of the nominees to make sure that people have some basics about who the folks are who would be coming in. And just, so how we're structured in our area, of course, we have Treasury and IRS, we have the Department of Labor, we have PBGC as the main agencies that we focus on. There's other agencies as well. And here we've got, but these are the main drivers of a lot of the stuff in not just the retirement space, but also in the healthcare space as well. We've got the Assistant Secretary for Tax Policy, Ken Keith. He has over 40 years experience going back to before the Tax Reform Act of '86, which is a long time ago. He's been a long-time lobbyist. I think he was the House Ways and Means staffer back in the Tax Reform Act time in '86. He's also been the Chief of Staff of the Joint Committee on Taxation. The JCT is a nonpartisan group that assists with tax writing in Congress and works with members of both parties. He's regarded as very experienced, knowledgeable, seemingly does not seem to have an employee benefits focus or executive compensation focus, much more of somebody who kind of knows where the bodies are buried and knows how to get things done from an administrative standpoint, and also knows how to work with Congress, which would be super important if we actually are going to have a big reconciliation bill.
Yeah, and so Dan Aronowitz,
yep.
I'll pick this one up. Yeah, so Dan Aronowitz is sort of the definition of an outsider as the EBSA undersecretary. Individual is the president of Encore Fiduciary. Encore Fiduciary actually wrote insurance policies that covered fiduciaries with respect to retirement and health plans, right? And so he had published a blog, you can see the link to the blog, that was unbelievably critical of the Department of Labor and specifically the EBSA with respect to some of their litigation activity and then also the regulatory activity that got the attention of the administration and actually earned him the opportunity to be the EBSA undersecretary. I think that one of the things we'll end up seeing with the EBSA undersecretary that you end up having is that this is a person that appears to be at odds with some of the thoughts that we would have, say, with the adequate consideration regulation, or potentially with respect to the common interest agreements. Dan Aronowitz had written a blog post pertaining to the common interest agreements, realizing that what the common interest agreements are a realization that the Department of Labor had been sharing information, private information that was obtained through subpoenas of employers and industry and service providers in the industry with plaintiffs' firms. And so if you have an individual who's writing insurance that is otherwise protecting companies from claims of plaintiffs, and you have to be nominated of the undersecretary of an organization that has otherwise been sharing information with plaintiffs, you can see where the conflicts arise. And so honestly, of the three individuals we talk about, this one's probably the largest firework opportunity between the three.
I agree. And I would caution, I mean, not to throw cold water at all on that, because I agree completely, number one. And number two, if you have not read this blog, I would read it. Like I would, if you want to understand what an incoming person thinks, I don't know that we've had a better opportunity to, I mean, I cannot think of any better opportunity with respect to somebody who spent so much time outside of the government to actually get a solid view of what their thinking is than we have right now by looking at this blog. I'd say the caution I have is twofold. Number one, I think it's going to be a while before we're going to see him actually put into place, actually approved and take his seat at EBSA, which, David, I know is something that you've talked about and been very sensitive to, the time it takes to get people into these offices, number one.
Yeah.
And number two,
it's important. Before that,
yeah,
so just to note people,
important.
yeah. Preston Rutledge was not appointed until December. Lisa Gomez was not appointed for, I think, 18 months. So even in good times, it takes about a year.
Yep. And this one may even be more complicated. The other thing to keep in mind is that he's still one person, and even with a lot of cuts at EBSA, it is still a Titanic that can be a little hard to move, and it is very difficult even for a person who has the strong view that he has, it would be very difficult for him to do things like kind of get into the details of, say, individual common interest agreements, or get into the details of, say, investigations that are occurring and kind of change the course of how those processes are done. That's a very tough thing for an EBSA secretary, assistant secretary to do. Last but not least, in terms of at least the nominees we're going to focus on, Janet Dillon. She actually was a prior chair of the EEOC, and I guess big picture, in the employee benefits world, not very well known, at least not to many of the people who I've asked about her about. That said, she has very intriguing experience. I mean, having general counsel roles at Burlington Stores, JCPenney, and U.S. Airways, I mean, we're highlighting those for a reason, in particular JCPenney and U.S. Airways. Many of you may be familiar with the fact that both of those last two companies had extensive dealings with PBGC related to their pension plans. And so while she seems to be an outsider, and while she may seem to not have what we would expect to, the type of experience that you might see, although we've had plenty of other PBGC directors who don't have the experience you might expect to see, I actually think that it's pretty highly likely that she has some really, really good practical experience, understanding what it's like to be on the other side of the table from PBGC in what can be very difficult negotiations and decisions and processes. So with that, let's spend a couple minutes on healthcare.
To touch a few things here on healthcare. We talked about this before, and I think it's important. What are the concepts of a plan that this administration has for healthcare? I mean, you look at this, there really aren't that many options you can actually build out. You can have private pay, sort of before the Affordable Care Act. You can have Medicare for all, national healthcare. You can have market-based individual plans, sort of the defined contribution of healthcare. Quickly go to the next slide. The repeal of the Affordable Care Act is extremely unpopular. Even as of January, it's at a 60% approval rating. Medicare for all, universal health care appears to be a non-starter in a world, because if you look at it, I mean, Medicaid seems to be on the chopping block. So large entitlements are unlikely to be added. And we do have ICRAs that came out of the Trump one, but the challenge with ICRAs, really the defined contribution nature of healthcare, is that it has to have access to efficient markets. And we know that from the exchanges that they don't appear to be efficient markets. And the way in which you put efficient markets in place is a public option. You have a defined contribution sort of HSA account that actually can go buy into the federal employee health plan system. What's that do? It brings us right back to death panels. And so interesting if you have a solution there. The other half of this is concepts of a plan, prescription drugs. Again, group negotiations or most favored nation status to try to lower costs. We also have, this thought of really sort of tackling pharmacy benefit managers. One thing to watch out for drugs, though, tariffs. We don't make all of our drugs here, and we don't make all of the materials to make our drugs here. So tariffs are going to end up impacting anything that happens with respect to our drug policy.
All right, and then wrapping up with retirement, and nowhere near as extensive as what David just spent on healthcare, because I don't think there's as much to say. Unlike healthcare, I don't really think there is much in the policy realm. I think the risk of changes on the retirement side are really come down to whether there's money that's needed. And in particular, with certain potential solutions, there could be a lot of money available to the extent that, for example, Roth, we've already seen the Roth door opened for mandatory HCE for Roth HCE people, not exactly the same as regular HCE, but the Roth HCE people are required to, as it implies, make their contributions in Roth. And will they go further with that? I mean, I think so far what we've heard is that, there's probably not a lot of appetite to touch retirement provisions in terms of, for revenue raisers, even to raise money. I think for some pretty obvious reasons. I mean, the fact is that retirement policy and retirement legislation has actually been an incredibly bipartisan endeavor over the years. I mean, not everybody likes everything we've gotten out of these various laws, but it's hard to argue that they haven't been bipartisan. And, I think there's a lot of folks who would like to see that continue. A lot of folks on the Hill would like to see that continue. And, but it's also true in the context of the discussions related to the current reconciliation bill. I mean, I think we've heard rumblings of $1 million tax bracket. I mean, who would have thought that, out of a Republican administration or Republican bill that we'd go up to back to 39.6%, or maybe even 40%, for people making $1 million or more, essentially an income tax increase. Now, whether that's, obviously that's a balloon, it's being floated for lots of various reasons to serve various purposes that may have nothing to do with it actually being something that would go into law. But to me, it's a pretty strong indication that at least some folks are struggling for revenue, and that's a dangerous place to be in our area.
Dominic, we did get one question, and I wanted to raise it to you because I've not had this. Have any of our clients, especially Taft-Hartley's, received direct outreach from Doge? I have not. Now, I don't spend a ton of time with Taft-Hartley's, but I have not heard that any of my clients receiving a direct communication from Doge.
Right, I have not either, and I would love the questioner to follow up, with the context of, if they are seeing these types of questions. I'm curious as to whether or not it's related, say, to the, the ARPA funding or something else. But I agree with you. I haven't heard it either. And so with that, I think we've addressed what's come in. I think we've gone through our agenda, and we have successfully wrapped up an hour. And so I will now bring us to a close. A webinar series, Transition, A Presidential Change, continues on April 29th, next week, at 2 p.m. The next session will look at what a second Trump administration could mean in regards to the Department of Justice enforcement activities. Sessions are held on Tuesdays at 2 p.m. Eastern Time. Please check your inbox for invitations on the upcoming topics. We hope that you can join us. And with that, thank you for joining us. Feel free to reach out to either one of us or anybody with whom you work at Thompson Hine with questions, and have a great day.